at Rutgers University School of Law.
You know, law schools play an integral role in shaping who our leaders, future leaders, are going to be. So what better place to go to law schools to teach them, right? To have humanity, to think globally, right? With regards to what do we want our Constitution to say? Who do we want to be?
There was always a legal component that would stop any progress, no matter how much we marched, no matter how many petitions we signed, no matter what we did. If the legal profession wasn't behind the things that we were doing, it wasn't going to matter.
Some of our students have agreed to have a conversation about issues related to the profession, their legal education, and how they got to law school. We're privileged that we can listen in. They've agreed to have this conversation in front of us, but we're not participants.
My colleagues helped me in this way by also doing their part and create 2 unanimous faculty resolutions. The first was to condemn violence against Black and brown people in our society. The second resolution was to teach and learn according to anti-racist principles. I said we have to document this because other law schools who signed on to the Law Dean's Anti-Racist Clearinghouse Project will need a template. They'll need a blueprint. So let's write about what we did.
And so we spent a lot of time really thinking about that. And so that led to writing several articles. I wrote one as well as Dermot Groom and Dean Conway and my colleagues Rebecca Saidman-Krause and Rebecca Schreiber. And so it was this 3 kind of part series of articles where we were really unpacking how as a law school, how as legal educators can we start to address the injustices that we're seeing.
We were then asked to present those at a conference at Rutgers University Law School. Remember I mentioned Kimberly Mutcherson? Well, she created a space for us through the Race and Law Review Journal to actually present our templated response to the murder of George Floyd and to systemic racial inequality perpetuated by law. At the presentation was the senior editor at the University of California Press.
So I reached out to Dean Conway by email, not knowing that she would even read it, let alone respond to it the next day. And we were on a Zoom the next week.
In that conversation, she said,
Dean Conway, this is not just a book that you're talking about. This is a book series.
And we need to write a book series that demonstrates step by step how to do what you were able to do at Dickinson Law. And so I took up the challenge. I said, all right, we'll do it. But I said, if we're gonna do this work, everyone has to be engaged with it. It cannot be a Dickinson Law project. It has to be bigger than anything we have ever done together in the Legal Academy. And we need a vehicle in which we can come together, not promoting one law school, but engaging all law schools. And that was the initial kernel of the idea of the Anti-Racist Development Institute.
You know, the Anti-Racist Development Institute, ADI, has been a powerful entity, and both my organization, my employer, LSAC, is a supporting founder, and myself, I'm a co-editor in one of the volume series. ADI is so important in terms of helping the larger legal community, and not just the legal community, education community, but the entire community think more succinctly about, you know, it's not just an individual, but as a collective community, how can we do this, and how can we bring it so it doesn't sit necessarily on this as a scholarly piece, but something that the everyday person would be able to read and absorb and embrace. And so I see my DEI work as it has transformed my own life over time, and now, I mean, it's almost the culmination of that with ADI as the project.
With the Anti-Racist Development Institute, we are putting a foundation under the work that we are doing. That foundation is rooted in coalition. It's rooted in a book series, Building an Anti-Racist Law School, Legal Academy, and Legal Profession. That's how we do the work. We are iterative in our work, tolerant of failure. Everything that the Anti-Racist Development Institute does is not made by those decisions are not made by a singular person. we are truly collaborative in all that we do.
A colleague said that, we went through a first revolution with, 1776. We went through a second revolution in 1865 at the end of chattel slavery. And we went to a third one, in my opinion, with the Civil Rights Acts in the 1960s. I think we're on the tip of the iceberg of another one.
When I saw the ADI and what they were talking to, I was absolutely blown away. First of all, I was so proud that it was my school, frankly. I think the location, it's almost funny to me that it would spring up here in a fairly conservative area. But it's just so exciting and it's so important.
I could talk about the work that we do, for hours. I could talk about, the book series and the various chapter contributors. And even as I think about the book series, the law professors and law deans and folks that are working on the book series really come to mind. And I think about their energy and their excitement. That excites me. That energizes me. That we are contributing to something that is a huge project. It's a huge undertaking, but it's so necessary. It's what the world needs right now.
So if I were to say, what do we need most in this work? What we need most is just people to engage authentically, but to engage.
You can clap. And we thought it was appropriate to show the video here. It is the first time it has ever been seen because we wanted to commemorate your centennial as a law school. So thank you so much, University of the Pacific McGeorge School of Law, for being a fabulous partner, but also for being here for this length of time to do exactly what needs to be done, create accessible pathways to the legal profession. I love where this law school sits. I love the community that is walking around. I love the fact that if you really did the math, you would wind up with about 70% people of color, people from intersectional identities, people with disabilities, people who are battling poverty. That's what your law school is all about. And it's led by a fabulous dean. We know that. But that dean, this work, as you saw in this video, is supported by so many people. And that's the collective of which I speak. That's the collective. So I want to thank everybody who's here, my brother at the water station. I want to thank my sister. I want to thank other folks that identify as they. I want to thank you all for being here for this conversation. And so after I do that, I always talk about people as folks with an X on the end. So now you know folks is everybody in the collective. So I did my thank yous. That's page 1. All right, now to pull this all together, because you saw the documentary, that really does give you the signposts of what this talk is going to be about. You heard the very last sentence where I talked about engagement. That's what I want at the end of this session with you. At the end of this session, I want you to write down on that document that we've given out, what will be your action? Okay? Everybody understand the assignment? Fantastic. So, in classic law professor style, here is our roadmap. And don't worry, the first 2 are longer than the last 3, so just focus and try to stay with me. or just come back in on the last two. I'm going to give you my observation of the necessity to engage with institutional anti-racism in legal education and in the legal profession. I'm glad we have our alumni here, so take note. I really want to hear what you have to say in response to this talk. And then we're going to get into why anti-racism as opposed to anything else, right? Then I'm going to talk with you about the indispensability of leadership. And then how we can emerge as leaders embracing anti-racism. Now, during this book series, I had to even counsel myself not to fall into the trap of talking about anti-racist leadership. And why is that? Trust me, I'm not going to call on you again. But that is because for many of us, and raise your hand if you think I have purchased with this statement, we don't even know the definition of leadership in the first instance. Raise your hand if you've ever been befuddled about what's it. We always hear, oh, a leader does this, or a leader does that. And I came from 27 years in the military, so a leader has a command voice. A leader is decisive. You know, they brainwashed me, right? But that's not really touching on what is leadership. And then it doesn't touch on who we regale as a leader. Because I tell you what, without that bio, you'd be like, who is that walking up here in that polka dot dress? Right? Or, more charitably, when I got out of my car yesterday, your wonderful students who I absolutely adore. Oh, orientation is over this way. Come over this way and then pick up your bag. And let me tell you why I was not upset about that. Here it is right here. You see? I was like, oh, really? Okay. I was like, oh, I love this place. I'm not going home. So I actually offer my observations based upon theorizing and practicing leadership, what that definition is, so that we can use it to think about what leaders can do to engage with anti-racism. And then I'll have concluding thoughts, and like any good exam, the answer to the question I asked you to write about is literally on this PowerPoint slide. Concluding thoughts and action. So just write your stuff down right now, and it'll all be fine. Okay, so let me get started. A little bit of theory for you. In Antiracism from Policy to Practice, David Gilborn lays it out on the line when he states, racist power structures saturate the classroom. When one attempts to disrupt racist power structures built on white supremacy, Gilborn concludes that the controversy then ensues. He locates the education system as a critical battleground in meeting these controversies and resolving them. He also points out the standards and accountability. These things are being replaced by, or actually replacing, professional reflection and innovation, leading to an authoritarian approach to knowledge acquisition and teaching and learning. My praxis work here with institutional anti-racism looks at three pillars. It looks at systems design, the mechanism to bring forth institutional anti-racism. It looks at anti-racism. And third, it looks to critical pedagogy. This explains why the authoritarian approach can get away with itself when you don't have those three things. When you don't have critical pedagogy, when you don't have a commitment to institutional anti-racism, and when you don't have a mechanism to roll it out like design thinking or systems design, what do we get in the classroom? Paulo Freire teaches us that we get the banking system of education. And that banking system means that students are in the classroom just waiting to have their cups filled with the sage's knowledge. That is the primary form of legal education. I'm going to tell you, because I've been to a lot of law schools as a student, and I have these gray hairs. That's what happened to me. And I went to Howard, and that's what happened to me. Why did that happen at Howard? It happened because we were a fourth-tier law school fighting to be recognized and legitimized by the authoritarian system. So do you think they taught us about Charles Hamilton Houston? No. Do you think they taught us about Frederick Douglass? No. Do you think they taught us about Ida B. Wells Barnett? No. What did they teach us? The rule against perpetuities. Yeah, I did it, property professors. I went there. That's what they taught us. And a bunch of other stuff that has transactional meaning, but does it do the work that we say we're doing as lawyer leaders? Gilborn counsels us that the education space is a key ideological background in which social policies, new initiatives, and strategies are tested. On this battleground, we can expect the damage can be inflicted, but we must also remain hopeful that progress is possible. Enter the vital work of engaging anti-racism in legal education and the legal profession. As institutions, law schools, like colleges and universities, shape and are shaped by the civil, political, legal, social, and economic norms in which they find themselves. This is true today, as well as at the beginning of the Western liberal arts tradition. Higher education, according to Theocharis Chromidas, explains that before World War II, it was for those belonging to the higher social classes. This model became the kernel of educational policies in Europe and generally in the Western world. Gerald Auerbach, anybody know that name? Good. In his book, Unequal Justice, provides a similar observation about legal education in America. He writes that law teachers and legal practitioners were always bound by the strong commitments made to the university law school and the corporate law firm. Legal education committed itself to the social system created by what bell hooks identified as the dominant white supremacist imperialist capitalist patriarchy. I call that for short the DWSIP. Write that down. You got notes, you got a pen. DWSICP. The dominant white supremacist imperialist capitalist patriarchy. And I use this frame to do the work of institutional anti-racism in law schools. Now remember, or learn in the first instance, I didn't say white people. You understand? Nod your heads. I didn't say white people. I said DWS, DWS, DWS. I'm not going to move on until I hear a cacophonous ICP. DWS. There you go. Just saying it doesn't mean you believe it. Okay? So according to RBAC, DWSICP adhered to governance by a legal elite and the exclusion of social and ethnic outsiders who, in the opinion of those elites, lack the necessary qualifications for elite membership in the legal profession. Arbach goes on to state that these lawyers subscribe rhetorically to the notion of law as a public profession, but invariably they guarded it as a private preserve, practicing caste politics under cover of patriotism and professionalism. This history is vital in our understanding of the origin story and the foundations of formal legal education. Likewise, this history justifies our focus on legal education and the legal profession as democratic institutions with legal, ethical, and moral duties. As with the baton handoff on the 4x4 relay race, we all were watching the Olympics, our duty is to continue to contest and then dismantle systems that scaffold racial inequality and intersectional injustice. Historicity speaks to the facts about people and events. To grasp that responsibility and that obligation that legal educators have, that lawyers have to engage anti-racism, historicity demands inspection of all facets of the development of legal education, of the development of the profession that we call noble. This may be known to some of us, but likely not to all. But I now summarize these facts and reasonable inferences of the origin story of legal education. Here it comes. Lawyers in the legal profession feature prominently in the formation and development of the United States. Lawyers were among those most powerful during the founding and the second founding of our nation. In these positions of power, lawyers decided who would be included and who would be excluded from society in general and the legal profession in particular. Pointedly, that power was used to build the slavocracy in what would become our United States. As such, legal education and the legal profession were and continue to be complicit in supporting and perpetuating systemic racial inequality and intersectional injustice. To doubt this, to fail to study this, to ignore this in our classes, in our papers, in our teaching and learning, is to ignore historicity. The facts of people and places is documented. Law and legal architecture in the colonial period and well into the earlier 20th century sanctioned the bondage of human beings. That same law and legal architecture reserved law practice exclusively, now I am going to say it, rich white men. These men established governments, the norms of society, and directed resources to benefit their specific interests. They built institutions, including ones devoted to higher education, to meet their needs. They buttressed their work by creating a human hierarchy to structure American society. This hierarchy scaffolded a racialized ideology adhering to the DWS. As I mentioned previously, I borrowed that from Bell Hooks, culture critic, feminist theorist, writer, scholar, and teacher in the 80s. She was absolutely amazing. Raise your hand if you know that name. Beautifully done. If you don't, I typically get my books. And the reason I do this is, number one, I love to read anything that anybody writes in my books that I ask them to write, because I read my books over and over again. So number one, I ask you to write something in my books. You can just pick a book. But I also hand it out because I want you to know what I'm looking at and what I'm thinking about. And I want you to see its legitimacy with these wonderful publishers. And I hope it inspires you to take action. So I'm going to hand these out, or maybe my colleagues will start with some folks in the back, in the middle, and in the front, and write anything you want in my book and sign your name. So you'll see something there from Bell Hooks. What she drew on in coming up with that DWSICP was primarily applied in the social science arena. So my contribution to this work is bringing that into law and legal architecture and really giving her context within the frames that we are accustomed to as lawyers. And there are so many connections, and you'll see them when I talk about my second topic, why anti-racism. But the DWSICP maintains a racialized status quo by building American institutions to benefit those within the sphere of whiteness, while disadvantaging all others relegated to the outside. Now I'm going to talk with you about spheres of whiteness, because again, you might think I'm talking about white people. So let me put a little bonnet, a bee in your bonnet. I am in close proximity to the sphere of whiteness. I, a black woman, draw on the sphere of whiteness. Do you know how I can demonstrate that to you? Somebody say, how? Good, how? You invited me here to talk. That is the demonstration of my proximity to whiteness. That means that I have access to levers. It's what lever I pull that makes the difference. Can I pull levers that will just benefit my self-interest? Absolutely. So I could use my proximity in the sphere of whiteness to do that if I so chose. And would anybody really rise up and critique me for it? No, not in this America. But they will critique me for what I'm talking with you about today. And again, I'm okay with that, because we need to have this discourse. That's why I'm okay with that, and that's why I'm here doing this work with you. So, what did the DWSICP do? They used law for their purposes. They used it to legalize slavery, slave codes, black codes, racialized violence, and terror. They wielded law expertly, making it exponentially complicit in rupturing human interconnectedness by rendering law useless to protect and enforce the civil and political rights of black people, women, and people having intersectional identities. This is the foundation on which formal legal education and the legal profession in the United States was built. Now, let me give you an example. Not even, directly the slavery example. So when we were starting law schools in the 1820s, the Litchfield model, in the northeast of this country, you heard what I said, right? In the northeast of this country, we started legal education. Why? To ensure that we can maintain dominance in white society, so that we could maintain the family with the woman at home growing our children. That's the original model. That's the Litchfield model. You can write that down. But then I'll show you what we did here. we said, okay, when we're constructing these formal models for law school and we're trying to push back on the Reconstruction Amendment's biracial promise, here's what we can do to be responsive. So, these advertisements that you see here demonstrate how that 1820s Litchfield model was brought to the 1850s and the 1890s after Reconstruction. In a Georgia law school that will remain unnamed, a legal education would be of great benefit to the large number of young men who intend to devote themselves to the honorable employment of cultivating, they said the plantations, I put in slave plantations, they inherit from their fathers. This is an advertisement. You know how we are on TikTok? This is on TikTok back in the 1850s. To them, a knowledge of the general principles of law are of inestimable value. Knowledge of the law, how to maintain your property. And your property in what? Humans. Another advertisement expressed many young gentlemen whose parents were planters and men of large means attended the school in order to make themselves more accomplished citizens. You gotta love language. Without intending, this one struck me. This is what struck me. Without intending to follow the legal profession as a business. What does that tell you? The ethics, the morality, the standards, the accountability. I'm not going to law school to learn those things. I'm going to law school to make sure my property is not inviolate. These examples demonstrate that legal education as a formal institution has performed exactly how it was designed over 150 years ago. It was designed to guarantee that those who pull the levers in constructing society retain power, dominion, and control. Thus, the historicity of legal education and the legal profession lay bare that slavery and its enforcement and law kept enslaved and free black men and women and folks out of law school and the legal profession. Subordination and Jane Crow kept all women out of legal education and the profession. And oppression kept most immigrants, most poor, and the shunned and ostracized out of legal education and the legal profession. And when I say shunned and ostracized, who do you think I mean? LGBTQ. That's what I mean. To engage institutional anti-racism in law would be to critique centuries of anti-blackness, sexism, colonialism, oppression, subordination, intersectional injustice, and persecution delivered in legal education, delivered in the practice of law, and delivered through the canonization in judicial precedent. Plainly, defending the United States Constitution and promoting a strong rule of law requires us to engage, to account, to atone for this historicity. I'm going to switch gears now and go to why anti-racism. Why not diversity, equity, inclusion, belonging? Why not equal opportunity? Why not any of that? We can all agree that anti-racism praxis is not new. Frederick Douglass delivered orations about anti-racism in the form of abolition and anti-slavery, For example, in his May 14th, 1857 speech responding to Chief Justice Taney's opinion in Dred Scott v. Sanford, he wrote, and I'm going to read this word for word because it is powerful. Within the Union, we have a firm basis of anti-slavery operation, national welfare, national prosperity, national reputation and honor, and national scrutiny, common rights, common duties, and common country are so many bridges over which we can march to the destruction of slavery. This is 1857. To fling away these advantages because James Buchanan is president or Judge Taney gives a lying decision in favor of slavery does not enter into my notion of common sense. There now clearly is no freedom from responsibility for slavery, but in the abolition of slavery, I hold it is our duty. Anybody have a torts class today? Our duty to restore to enslaved millions their precious and God-given rights. He goes on, the more we have done by our voice and our votes in times past to rivet their galling fetters. I love this language. What does that mean? The bonds that keep us under and in the yoke. That's what that means. A former enslaved person wrote to rivet their galling fetters, binding their chains. The more clearly and solemnly comes the sense of duty to undo what we have done. Racism, anti-racism. Slavery, anti-slavery. You get it? This is the parallelism he's setting up. While men thus respect law, it becomes a serious matter so to interpret the law as to make it operate against liberty. Can we use this in our constitutional law classes? Absolutely. I have a quarrel, he says, with those who fling the supreme law of this land between the slave and freedom. It is a serious matter to fling the weight of the Constitution against the cause of human liberty, and those who do it take upon them a heavy responsibility. He's not, and if anyone has studied Frederick Douglass, he was not, oh, I hate the nation. He was like, I love this nation. He was like, you are not going to deport me to Liberia. The love that he has to say, take upon them a heavy responsibility. He's not damning them to eternal hell. He's saying, take responsibility. That is a sure sign of love if I ever saw one. From Reconstruction to the nadir, Black women like Frances Ellen Watkins Harper used anti-racism to contest their experiences with the triple bind of racism, sexism, and classism in pursuit of social, civil, political, and economic reform through humanity, equality, truth, and justice. Specifically, Harper stated, now, slavery as an institution has been overthrown, but slavery as an idea still lives on in the American Republic. And the problem and the duty of the present hour is this. Right? She's not saying I hate America. She says, okay, temporality is important. Now, what do we need to do now? Is what she said. Whether there is strength enough, wisdom enough, and virtue enough in our American nation to lift it out of trouble, whether by its legislation and jurisprudence. This is a non-lawyer, people. These distinctions between man and man on account of his race, color, or descent shall cease. Last year, my friends, I spoke of the nation's great opportunity. The nation's great opportunity. I still think we have one of the greatest opportunities, one of the sublimest chances. This is a love letter to America from a black woman in the 1850s. We have one of the sublimest chances ever put into the hands of a nation or people. And what she was talking about was reform. She was talking about the lawyer's craft. Reform. Ida B. Wells Barnett engaged anti-racism through her anti-lynching crusade by writing in-depth reports and exposés about the torture and terror experienced by black people during the post-Reconstruction era. Civil rights leaders such as Carter G. Woodson, Charles Hamilton Houston, Martin Luther King, Medgar Evers, Marilee Evers Williams, Ella Baker, and Fannie Lou Hamer were active practitioners of anti-racism in their work to contest systemic racism, systemic poverty, systemic injustices. I say all this to you to let you know anti-racism is not new. So let's not fall victim to those misidentifications, the misinformation that actually to be anti-racist is to somehow be racist. No, because literally we are commanders of language. So yes, anti-racism is anti-racism. And it breathes life into the 14th Amendment. It shows the 14th Amendment's purpose to have a biracial, multiracial, multicultural, multi-ethnic, intersectional democracy. So don't let legal opinions by our current Supreme Court disavow you of that fact. That is what the 14th Amendment said. And know that the justices who sat there with the SFFA, or the justices who sat there in the Dred Scott decision, know that they were self-interested. And when you are self-interested, you do things against others' interests. That's the DWSICP. That's the difference between me being here having this conversation and me say, oh, I'll just act like none of this is happening and I'll talk to you about intellectual property law. That's the difference. All right. I had a lot more, but I'm not going to bore you with that. I want to give you constructs now, because we all are lawyers or lawyers waiting to be. So we need a good elemental test. We got 3 elements. The first, the integrity to face and acknowledge the complicity of law in the design of systems of oppression and the existence and perpetuation of the DWSICP. Element 2, acquiring knowledge about the American system of laws through teaching and learning. Now, this is a really important one, because how many of you are faculty? Raise your hand. Okay, great. Now, of those hands that are raised, how many people feel comfortable talking about the history of the slaveocracy as I talked about today? Raise your hands. Exactly, right? I like the halfway, you know. I might stumble through that. That's okay. Because what do we do as faculty better than anything else? We learn. We learn. And like those books I'm passing out, any faculty member in this room can read each of those books in a day. You can learn. And then what do we have in our double ALS? We got networks where we can call a friend. You know that TV show, Phone a Friend, because you want to win $1 million, right? If I put $1 million on the table, you be phoning that friend. Tell me a little bit about this anti-racism, right? Let's be real. So that's the second element. You can teach and learn, so don't be afraid to do it. And don't be afraid to fail when you do it. Because all you have to do in that classroom is say, I was not on it today. I'm going to go back and get some more knowledge from the book. Or, why don't you help me? Let's do a project together and learn this together. And that's what Paulo Freire talks about when he's saying that the oppressor and the oppressed in the classroom can learn with each other. I don't have to be the sage on the stage. I can have a sage dress, but I don't have to be the one who knows it all. And there is nothing more liberating in a classroom to say, I don't know. But you know what? Back in my time, there's a horn book. All the lawyers of a certain age are like, yeah, that's my kind of woman talking about a horn book. Right. That's what you do in the classroom. But you have the capacity because you have built the theoretical frameworks. You have the capacity to turn that knowledge into disseminated theory. That's what you're expert at. So it's like, put it in the machine and then let it come out. And then try it all over again and see if it comes out differently. What does that sound like? Right. That's how we synthesize rules of law, right? Exactly right. It's what we do. So this was built for law school. Element 3, act. You know how many people call me up and go, oh my God. Oh my God. One of the students in the classroom used the word nigger. I'm like, yeah, okay. All right, then what did you do? I was paralyzed. Okay. So what are we going to do about that? What do you want to do? I just don't know. I'm calling you. I was like, do you want me to teach your class? No, Dean. Okay, what are we going to do? Well, maybe I can craft a response back in the classroom the next day. I said, look at you. You're doing it. That's the action. You're doing it. Now, what do you need from me? Let's workshop it. Let's see how it sounds. Coming in your voice, in your lexicon, in your language. And then the minute you do it, call me and tell me how it, oh, Dean, it was great. Okay, that'll be $500. All right. I want to get to the indispensability of leadership, and I promise I'm bringing this home. What time was I supposed to stop? See. I love you. An author and a scholar whom I admire very much, Helen Liu in Australia, delivered one of the most piercing critiques of leadership scholarship. In her book, Redeeming Leadership, Liu states that leadership is socially constructed. I love this. And that this social construction is informed by power, both of which create a definitional vacuity. I'm like, I love this woman and her language. That allows those with power to decide which interpretation of leadership matters most. Wow. So what she said in a nutshell, because I am going to cut this a little short, she said in a nutshell, well, if we keep defining effective leadership, not leadership, but if we keep defining effective leadership using male traits, how the heck can women be brought into this space and succeed as effective leaders in the first instance, but also succeed in applying what positionality women have or folks have in their intersectional identities to the leadership construct. Because we keep measuring leadership, frankly, by military men. That's where a lot of our leadership scholarship comes from. And let me tell you, I was in the military 27 years, and I had wonderful commanders, wonderful superior officers who I learned heaps from. But there was this expectation that you model your leadership off of that male identity. And nothing could be less male than what you got up here. Right? I love bright colors. I like my twists. I love my glasses. I love all this. Right? Yeah, you can clap on that. Right? I love all this. But it was not the depiction of leadership. So the critiques that I have is that this extensive literature doesn't give a definition, that the definitional vacuity routinely describes leadership by saying, here are some traits, here are some behaviors, and here are some styles. Doesn't tell you what leadership is. And then the last critique I have is that it comes from these military or organizational literature pieces that center the dominant white patriarchy. So, I've created my own definition, as we law professors like to do. I'm not going to go through all this with you, but what I'm going to say is, if you think about this as a definition, it moves you to think beyond yourself and how you center your identity. So I am a woman, but I have men, and I have intersex, and I have LGBTQ, and I have, I don't want to lie, I don't think we have on our faculty or staff trans. Oh, we do? Oh, yes, we do. We do. I'm not lying. We have a trans faculty member. Yes, we do, and I love her. So I have to engage my own understanding of positionality in order to understand how they receive and respond to leadership. I know that my positionality casts me as dean. That has already authoritarian elements built in. So I have to know that when I'm dealing with these intersecting identities. That's the importance of positionality. Then the situational awareness that helps to define leadership. I have to know when to act in what way depending on the situation. Again, that helps to take in identities and markers of others. And then dimensional. I love dimensional. Dimensional actually refers to how many lived experiences do I have or have access to inform my leadership. Do I have experience with poverty? Yes, I do. Do I have experience with rurality? Yes, I do. Do I have experience with trauma? Yes, I do. So that dimensional element of leadership allows you to think 10 steps ahead when dealing with a challenge or a set of circumstances. But if we have leaders without dimensionality, who do not understand their positionality, who are not capable of being situationally aware, we are going to have very narrow approaches to leadership. So I'm going to give you my definition because I like it. Leadership is dimensional, situational, and positional. It is a concept that is both abstract and pliable. It is also forged by internal, liminal, and external forces that, when exerted, move an object or scenario in either expected or unexpected ways. Now, if I were to break this down, for example, what does liminal mean? Think about an immigrant who has a not sure path to citizenship. We don't necessarily cast that person out. But what might our leadership ignore? Their circumstance or set of circumstances. Yeah, because if we're not dimensionally aware of their liminal position, we don't know how to use our processes, our practices, and our policies to help them through what they're dealing with. It is the trusting and understanding of the self, the knowledge of the surrounding landscape, the prescience to see and evaluate what lies ahead, the courage to vision toward a sustainable future, the capacity to develop colleagues committed to serving the vision and the mission, the wisdom to learn from past successes and failures, the fortitude to adapt to changing circumstances, and the resilience to navigate through crucible experiences with humility. That is a definition of leadership. Now, I'll conclude because this is long, and I'm sweating up here. What does this mean for us as emerging leaders? To use this construct, this definition of leadership, to embrace anti-racism. It means that we are able to see systemic racial inequality as the complexity that it is. That we're able to see the complexity of interlocking systems of oppression. That we don't just stick our heads like the ostrich in the sand and say, well, we have to govern for the majority. No, actually, by looking at these users at the end of our spectrum and governing for these intersectional identities, John F. Kennedy, I love this, all boats rise. We become more empathetic. We become more discerning. We become more capable in our leadership. We become more capable of spotting when something is about to go off a cliff because we are practicing it. And I love this about the law because what is it? It's practice. Allen Iverson, practice is practice. Yes, Allen, get on that court and practice. That's what they were saying. So I'm going to leave you. I'm going to publish this in the law review. So you get to read the whole thing because it's a lot. I'm going to conclude here. Historians, commentators, and advocates have identified the historical centrality and complicity of law in upholding white supremacy as the most explosive issue in American civilization. You know what that means? If we confront, I didn't say solve, if we confront this, we are confronting something big, which means that when another big thing comes, what are we able to do? And deal with it. That's all this means. The upholding of the DWSICP and the resulting interlocking crises that are causing deep fissures in our democracy have and continue to reverberate wildly in our law spaces. Legal education can no longer afford to reproduce racialized, gendered, and unjust intersectional hierarchies. Legal education, for its part, must be on the front lines to dismantle human hierarchies. For our part, legal educators have the responsibility to deliver a program of legal education that acknowledges and acts to instantiate democracy that meaningfully addresses systemic racial inequality and intersectional injustice. Institutional anti-racism praxis unmasks the complicity of law and legal systems that have plagued society, and it works to reimagine how both can be used for emancipatory liberation from oppression. I look forward to the action you will take as you write on that paper to bring forth emancipatory liberation. Thank you. I am happy And thank you all for staying. I mean, look, y'all are lovely and wonderful. Thank you. There is nothing more validating than when people listen. Thank you. Questions? They really did hold out. I am so thankful. Excellent. Mm-hmm. Mm-hmm. So you confront it by the discourse. When we make these documentaries, we really have to think about what's the message that we are trying to convey. And the message we're trying to convey, frankly, is that of Frances Ellen Watkins Harper and one of hope. So it would be very difficult to bring that message of hope with continued focus on police in the United States. That can be done in a lot of different venues. It can be done in the criminal law classroom. It can be done out with your clinics doing advocacy in the community. Those things can be done. But what I saw that was not available was a framework for hope through anti-racism. We can always complain about the police, but what's the framework to actually act? That's why. But great question and great critique. Absolutely. Right. Mm-hmm. Yes. Great comment. Yes. Consistent with the response I gave about the hope and the book that's going around Bell Hooks, all about love. And raise your hand if you have children, right? We love them. Do we let them get away with anything they want to do? Hell no. Because then everybody's going to call you up, the principal, the doctor, and then you in trouble with, what is that, Child Protective Services. You know, we got to protect ourselves, right? If you ground your comment, if you ground your writing, if you ground your discourse in love, and you actually tell people that, then you can talk your truth. So, you know, I'm a dean. I was feeling for you yesterday when you were, you know, doing orientation, because I get real nervous at orientation. It is that, and graduation suck for a dean. And it sucks not because you don't want to do it. You want to do it, but here are these people, and they are resting their decision to go to law school on the thing that you say in 5 minutes. Like, they could walk out that door and be like, I am not doing this after I heard what he said. So it's very scary. But graduation to me is the worst, because you have people's parents and families and loved ones, and you got to inspire literally 600 people. It's crazy scary. But this year, you know what I did? I mean, I totally went there. I was like, this is about love. And if you all don't hear that word ever in law school or in law practice, know that your dean said the following: I love you. And I meant it. And I was shocked at myself. I was like, I think I meant that. If you ground everything that you do in this concept of love, it will become easier and easier to talk about it. You have to know that. And what bell hooks teaches us is love isn't the mwah, mwah, mwah. I did love that, and I gave her kisses. And that is a kind of love. But bell hooks talks about love in the showing of respect, in the showing of dignity, in the listening, in the caring, in the thoughtfulness, and in the ability to engage conflict in order to bring forth truth. So if you're in the classroom and you're a black woman in the classroom and you hear somebody say that epithet, you have to love them and yourself enough. Say, okay, first, let me tell you the history of that word. And second, let me tell you how it makes me feel. And third, let me tell you how it shuts down my teaching and learning process when you say that with reckless abandon. And I will never say an epithet that maligns your background or your history, because I will not engage with that. And then you say, okay, you may not be ready, but when you are, I'm here with that love. And then you go talk to the professor like, look, we got to figure this out. How you go? Come on, let's practice this, seriously, because that should not be happening in the classroom. That's what you do. Does that help? Great. Oh, yeah, I should. Yeah, because there's a lot of other stuff that, yeah. Oh, man, I was working it out. So here's all the stuff we did to build an anti-racist law school. That and that, but here's what we want you to do. So get your phones out and take a picture of that. We are going to have at our second convening Dr. Eddie Glaude, who's going to keynote our Anti-Racist Development Institute second convening. It is going to be phenomenal. If you have never been to Carlisle, Pennsylvania, get your ticket now. It is fabulous. And my husband will barbecue for you. So come and learn about what we are doing at Penn State Dickinson Law and its Anti-Racist Development Institute. Thank you.